going to give it another high noon. So I think we should get going. I don't want to keep anybody later than they want to be here on a Friday afternoon. Welcome to this month's edition of Lawyers and Friends. This our topic today is Comp 101, and we literally mean that like Comp 101, like intro level college course. My friend today is Brendan Shannon. Say hi, Brendan.
Hi, happy to be here.
Thank you for volunteering. When everybody else took a step back, you were the lone guy there. And we have a time limit on each one of the rules that we're going to give you today. You'll see it in our PowerPoint of 30 seconds per rule. I don't think we're going to take anywhere close to 30 seconds per rule, but we're going to make sure that we get out of here, get you out of here on your lunch hour well within the hour today. So
I feel like the hardest part is going to be talking fast, though. Might slip up on some words.
Yeah, I might. There's a couple. Some of the rules are so short, it's no problem. But other of the rules are a little bit longer. And then, of course, I suffer from an inability to not talk about anything. And since I sort of have no life and I live and breathe this stuff, I may have a tendency to go on a roll. But we have Max here to keep us in line, our producer and director, and he's going to make sure that we're staying within our 30 seconds. So just a couple of introductory pieces of, lawyerese type of cautions and warnings. Please know that this is an advertisement, and prior results do not guarantee similar outcomes. And secondly, that nothing in this presentation should be construed as constituting an attorney-client relationship or legal advice, and you should always consult with an attorney about your specific case before making any decisions about the matter. So with that being said, let's get going into our first rule. All right, I'm going to start with one. Rule number one, your pre-hearing conference statement must be filed 10 days before the pre-hearing conference, or most defenses are waived. So very important that we get our pre-hearing conference statement in 10 days prior to the pre-hearing conference.
I like the music. Rule number two. The C3 is only required in controversy claims, and that can be found under 300.38 of the rules. It still is always good to request a C3, especially if you anticipate that there might be disputed sites on the line.
Hey, Max, yeah, the music is actually, so I'm not sure if you can turn the music off. Okay, great. Let's go on to rule three. Uh-oh. Rule number three, a C3 form must be filled out in its entirety. If the claimant leaves a question blank, such as whether or not there was a prior injury, that is a question that is asked on the C3 to the same body part, then you can take the position on a controverted case that the C3 is not complete and that the pre-hearing conference cannot go forward.
All right, rule number four.
Thank you, Kathy. Yes, the music is not necessarily the best addition, but it's in the PowerPoint, so we're going to have to deal with it for a time being. Rule number four.
Rule number four. All right. Has it popped up yet?
Not yet.
Well, I've got it. All right. So rule number four, pre-hearing did we lose it?
Yeah, I don't see the PowerPoint anymore, but you and I have the list of rules, so we can continue on.
Okay, perfect. Yeah. So rule number four, pre-hearing conference statements must list witnesses and what they are expected to testify to. Otherwise, lay witnesses can be deemed waived. This is very important, and it applies to both the employer carrier as well as the claimant. So a lot of times claimants submit fairly rudimentary pre-hearing conference statements. So this is an important thing to look out for, because if they try and produce a witness later on, you could potentially have an argument that they waived the right to produce that witness.
Excellent. All right, rule number 5, under rule 300.38, if the claimant's attorney doesn't disclose evidence on their pre-hearing conference statement and then decides that they want to call a witness who wasn't named, like Brendan just explained to you in rule 4, it is not going to, many times the judges are going to give the claimants the benefit of the doubt. However, they are supposed to reduce their fee if for some reason there's discovery that's used to prosecute a trial or to claim a claim that was not identified on the pre-hearing conference statement. The claimant's attorney's fees must be reduced.
All right. Rule number 6. And rule number 6 is an interesting one. Under case law, Love v. Pleasantville, the waiver of defenses does not mean that the claimant doesn't have to establish a sufficient causal nexus between employment and an accident that caused his or her injuries. So if there's an error with the pre-hearing conference statement that results in waiver, it doesn't, it means that the claimant still has to prove causal relationship between their injuries and their accident.
In other words, all is not lost.
Correct.
Rule number 7. We're kind of dealing in sort of general topics here too. That was all those rules pertain to controverted cases. We're now going to start talking about jurisdiction, the board's jurisdiction. So rule number 7, the board has continuing jurisdiction to modify its prior decisions, subject to the limitations that are contained in rule section 123. In so doing, by modifying a prior award, this does not violate a claimant's rights. Even if there was a prior award and it was labeled as a tentative award, and then it was found and there was a period of no compensable lost time, because the board has continuing jurisdiction, that is not violative of the claimant's due process rights.
Okay, rule number 8, under section 123 of the comp law, there's 3 parts to the law. One is that the board does not have jurisdiction to award indemnity in a closed file more than 8 years after the last payment of compensation and or 18 years from the date of accident. This section of 123 jurisdiction does not alter medical benefits.
So people sometimes ask us whether or not there's a statute of limitations in comp. This is kind of akin to a statute of limitations. As Brendan noted, section 123 has 3 limitations on the board's continuing jurisdiction, and the second of those is that the board cannot hear a claim more than 7 years after an opportunity to be heard on the merits where all parties have been provided notice has occurred. So on a controverted claim where there was an initial pre-hearing conference or an initial hearing where all parties were provided notice of the hearing, if the board closes that case or marks it NFA without any findings, and then a claimant tries to reopen that case more than 7 years after the date of injury, then you can't do it. It's the board lacks the jurisdiction to entertain that claim.
Rule number 10 is a unique one. Section 123 being a jurisdictional rule means that it cannot be waived. For example, you could mistakenly agree to pay awards despite 123 applicability at a hearing and a written stipulation, not note an exception at the hearing, pay those awards, and file the appeal against paying those awards 6 months after the notice of decision. So everything's wrong here, and 123 should still be found to apply.
Because of it's a jurisdictional limitation. The board only has that authority, which is granted to it by the legislature. Now we're going to move on to procedural rules. Rule number 11, employers are required to pay for all disabilities or death which arise out of or in the course of employment without regard to fault with limited exceptions. So this is the basic workers' compensation statute, right? That if you have an injury or a disability that arises out of or in the course of your employment, your employer is required to pay for the results of that injury or disability without regard to whether or not you were at fault.
Rule number 12. Another basic provision, there is no liability for compensation when the injury has been solely occasioned by intoxication from alcohol or a controlled substance of the injured employee while on duty, or by willful intention of the injured employee to bring about the injury or death of himself or another or where the injury was sustained in or caused by voluntary participation in an off-duty athletic activity not constituting part of the employee's work-related duties unless the employer A, requires the employee to participate in such activity, B, compensates the employee for participating in such activity, or C, otherwise sponsors the activity. And I think the one thing to note here is, in terms of intoxication, the key word is solely occasioned by intoxication. That could lead to some litigation on whether the alcohol or controlled substance was the sole reason for the claimant's resulting injuries.
So this is the exception to the rule that if your injury or death arises out of and in the course of your employment, that you're entitled to workers' compensation. Rule number 13, workers' compensation. Coming, I know it is. Workers' compensation is the exclusive remedy for an employee's injury or death arising out of and in the course of employment with limited exceptions. So this is the flip side, okay? This is the grand bargain that we always talk about. An employee cannot sue their employer for an injury or for death that arises out of and in the course of their employment, except with limited exceptions.
Rule number 14. An exception to the exclusive remedy doctrine is if an employer fails to secure the payment of compensation for his or her injured employees and their dependents. In such a case, the employee may, at his or her option, elect to claim compensation under this chapter or to maintain an action in the courts for damages on account of such injury. And in such an action, it shall not be necessary to plead or prove freedom from contributory negligence, nor may the defendant plead as a defense that the injury was caused by the negligence of a fellow servant, nor that the employee assumed the risk of his or her employment, nor that the injury was due to the contributory negligence of the employee.
So we just again looked at the general rule is that an employee cannot sue their employer for an injury that arises out of and in the course of employment. There are exceptions to that, just like there's an exception to the exclusive remedy doctrine. And one of those is if the employer doesn't get workers' comp coverage, and that makes sense. Like, why should the employer be protected if they didn't get the coverage they were required to get? And then the second general broad category of exceptions to that rule is intentional torts. So if your employer comes up and purposely punches you in the nose, you have the option of either bringing a workers' compensation action or you can sue your employer for the intentional tort. And because comp is a no-fault statute, you would not have to, your employer wouldn't be able to assert affirmative defenses like contributory negligence on a lawsuit that the employee would bring against their employer. And that's only fair as well, because those kinds of things can't be raised in comp. Rule number 15, timely notice. People always forget that Section 18, which is the notice section of the statute, requires written notice of an injury for which compensation is payable, and that has to be given to the employer within 30 days after the accident causing the injury. Remember, it has to be written.
Rule number 16, which segues nicely into Rule 17. Under Section 21, there's established a presumption that sufficient notice was given unless substantial evidence to the contrary is produced. The section provides that the statutory bar will not be applied upon showing that notice for some sufficient reason could not have been given, or on the ground that the employer had knowledge of the accident, or on the ground that the employer has not been prejudiced by such failure to give notice.
So, and again, these are the exceptions to the rule about written notice, but it's important to know that written notice is required, and then there are these exceptions. And Rule 17 talks about it's the claimant's burden of demonstrating that the employer was not prejudiced by any delay in providing notice. So in Rule 16, Brendan just talked about one of the exceptions to providing written notice is that there was no prejudice to the employer. Well, if that's the case and the claimant wants to be excused for not providing written notice within 30 days, it's the claimant's burden to prove that there was no prejudice.
And one thing I'll just note on that rule, while there is third department case law applying the burden to the claimant, I think a lot of times on our end, it makes sense to sort of affirmatively argue that that there was prejudice. All right, moving on to rule number 18. If the certification section on an RFA is not filled out, the board may deny taking further action until the RFA is properly certified. there is a list of instances where there doesn't need to be a certification that there was contact with claimant's counsel. However, you do have to properly fill it out still by saying not applicable under the section. An example of that would be there's SLU opinions in the board file. It's time for a hearing on SLU. You don't need to contact the other side, but you do need to fill it out properly.
Rule number 19. You should always advise a represented claimant that you, an adjuster, or examiner, or attorney cannot speak directly to that individual, and all communication has to go through their attorney. This is a rule that is born from the rules of professional responsibility, that you should not talk to a represented party.
Rule number 20 is a big one, and I think Melissa might have something to say about it. Under Board Rules 310 and 303.8, depositions begin with cross-examination, and there's not an entitlement to direct examination. In comp, the doctor's reports stand as their direct testimony.
And Brendan is right. I do have something to say about this. I recently stopped a deposition because after we qualified the doctor, it was an attending physician. After we qualified the doctor, claimant's attorney was insisting upon doing a direct examination of the doctor. And I had very good strategic reasons for wanting to perform a cross-examination before the claimant's attorney got a shot at the doctor. There were some, I did not want the doctor to be able to be rehabilitated, basically. I wanted to launch it across, and there was a correspondence from from the claimant to the doctor, and I wanted to explore the possibility that she had unduly influenced the doctor's opinion, especially since he changed his opinion from it being a non-comp condition to a comp condition after she sent the letter. And so I stopped the deposition and refused to go forward with it. We went in front of the judge. We ended up settling the case on the issue that was being litigated, and so we didn't need to redo the deposition, but because the doctor was entitled to a fee because he did show up for the deposition, we'd asked that fee be awarded against claimant's counsel, and the judge agreed. Apparently, she talked to the supervising law judge in the Buffalo district about the issue, who then consulted with general counsel's office, and they agreed that we were right, that there is no entitlement to a direct examination, and claimant's insistence that we perform a direct examination, and then our decision to stop the deposition, which, of course, the doctor, because he appeared, was entitled to a fee, but we were not liable to pay that fee because we were forced to pay the deposition because claimant's counsel took a position that was not supported by the regulation. I know I took more than 30 seconds on that, but we're flying through other ones, so I'm fine. Yeah. Okay, Rule 21. A claimant who does not attempt to schedule, or subpoena a doctor within the time frame allowed for depositions of doctors shall be deemed to waive the right to cross-examine an independent medical examiner. So this is true really for both sides. If you sit on your rights and then you don't try to do anything to enforce them, don't be surprised when you lose them.
Rule number 22, to file an appeal to the board, you need to note your exception for the record and file an RB 89 within 30 days of the filing of the notice of decision. I would just note that the exceptions noted at the hearing need to be specific to the issues being appealed. So you can't just generally note your exception. You have to say, we note our exception to XYZ, and here's why.
Yeah, it's a very technical. Well, you can actually note one exception to all findings at the hearing if you intend upon filing an appeal against all the findings that were made. So, I mean, that's just a very dangerous way to note your exception. So Brendan's recommendation is an excellent one. Next rule is rule number 23. If you're filing a rebuttal to an appeal, you have to file your RB 89.1 within 30 days, actually, of that appeal being not just filed, but served upon you. So the time in which to file your rebuttal starts within 30 days of when it's served.
Rule 24. TPAs are not considered parties of interest for purposes of service. For appeals, rebuttals, etc., check to see if the claimant served the actual party of interest, the carrier, rather than just the TPA.
That one's easy. That one's pretty self-explanatory. Rule number 25. This is a good one. Awards are stayed pending resolution of an application for review. That really should say benefits are stayed pending resolution of an application for review. So if you're objecting to surgical, a CA.1 that was found in the provider's favor for a surgery bill. It's a $50,000 bill. You don't have to pay that until you receive an adverse decision on that. If the flip side of that is if you're appealing a schedule loss of use award and you concede a 10% schedule and a 20% schedule was awarded, you must go ahead and pay the part of the schedule to which you don't object during the pendency of the application for review, or you can be subjected to the 20% penalty.
Rule 26, benefits are not stayed pending resolution of an application for full board review, be it discretionary or mandatory.
There was an issue about it since there is an entitlement to a mandatory full board review. There was a question a number of years ago, probably 2 decades ago now that I'm thinking about it, about whether or not you would have to make payment of an award during a discretionary, or excuse me, a mandatory full board review. And the answer to that question was definitively determined in the affirmative. You do have to pay. Rule number 27. Upon a favorable ruling from the third department, the payer is entitled to reimbursement of payments if you are required to make those before the favorable ruling. So our same surgical example, you're found liable for a surgery bill of $50,000. You file your application for review. You don't have to pay it while that is pending, but then the board panel comes back and says that you're liable for it. You then take your appeal to the third department. You have to make payment of the surgical bill while your appeal is pending to the third department. But if the third department agrees with your position and reverses the board and says you're not liable for the surgery bill, there is an administrative fund for which you will be reimbursed for the payments that you had to make pending resolution by the third department.
And likewise, upon a favorable ruling following an application for full board review, a payer is entitled to reimbursement of payments it was required to make before the favorable ruling.
Which is a little not really intuitive, because when you look at the regulation, it doesn't, or the statute, it doesn't actually include applications for mandatory or discretionary full board review in the directive, indicating that a payer is entitled to reimbursement. However, we can tell you that the board has adopted the rule that if the full board does reverses the board panel and makes a finding that you don't have to pay some benefit that the board panel said that you had to pay, you're entitled to reimbursement from that same administrative fund. Sometimes it's worth it to go for that application for full board review. Let's see, we're on Rule 29.
Yeah.
Hearing loss, there's no segue here at all, because we're going to talk about hearing loss claims. They differ from other injuries because occupational hearing loss claims can be reported up to 3 months after the injured worker or the worker is removed from the injurious exposure, or 3 months after leaving the company or the employer. Usually that's retirement, or within 2 years of when the worker knew or should have known that the hearing loss was related to employment. So notice and timely claim filing are different in hearing loss claims.
Rule number 30, an employee's rights to comp benefits may not be waived except pursuant to Section 32, meaning where the claimant settles their claim.
That's kind of self-explanatory. Although we recently had a claim where an individual was injured in a motor vehicle accident on the way to PT for a compensable condition, which would normally make the injury sustained in the motor vehicle accident consequential. And they did not pursue, it was an Uber, the claimant was in an Uber, which led to a very large recovery from Uber for the negligence of the Uber driver while the claimant was in the vehicle. And so we took the position we should be able to take a credit against the recovery that the claimant received, but they did not pursue the injuries from the motor vehicle accident as consequential. And the board found that the claimant was not required to pursue those injuries. I think that you might get a different result on that, depending upon the arguments that were advanced to the board panel. Let's see, we're moving on to average weekly wage. Rule number 31, under Kellish, which is a seminal decision on average weekly wage calculations, the average weekly wage must accurately reflect the earnings. We cite this as a general principle for you because sometimes you get somebody who's a per diem worker who works very limited hours, and if you apply to 200 multiple or some sort of multiple to the claimant's wages, you would end up with some grossly inflated average weekly wage. So there are times under Kellish where none of the calculations under Section 14 would be appropriate, and then you revert to Kellish being used to accurately reflect the claimant's actual earnings.
All right, rule number 32, I'm going to walk through the calculation method when using a multiple. So the annual wage on the C240 is divided by the number of days worked, and then you multiply that answer by the appropriate multiple. So it would be a 200 multiple for a 4-day worker, 260 for a 5-day worker, and a 300 multiple for a 6-day worker. Then divide that result by 52 weeks. So an example would be a 5-day worker works 250 days, made $55,000. $55,000 divided by 250 equals 220. 220 times 260 equals 57,200. 57,200 divided by 52 equals 1,100. And there you go. We've got the AWW calculation.
Perfect. That, by the way, when you divide the gross wages by the number of days that the claimant worked, that's referred to as the average daily wage. That's essentially what the person earns every day they work. Rule 33. Under Lamiano, which is another seminal case, an adjustment in an average weekly wage for minors' wage expectancy is limited to the same or similar employment to which the claimant was employed at the time of the accident. Right, so a Lamiano payroll you may hear is a payroll that you will need to obtain, which shows what the claimant might have made based on a similar worker who was injured. The similar worker who was the same age that the claimant was, and then who was continued to work at that same employer until the age of 25 years old. Frequently, people are unable to come up with Lamiano payroll because, as you imagine, you'd have to be a pretty big operation in order to find somebody who was the same age as the claimant, who then continued at the time of the injury, who then continued to work for the employer until 25 years of age.
Rule number 34, if a claimant worked for an employer for less than a year, you should obtain a payroll of a similar worker who worked for a full year and file that as soon as possible, or provide evidence that such a letter cannot be provided because there was no similar worker. See this happen fairly often. And in a situation like that, you want to find a similarly situated worker who was working at the time of the accident for at least a year beforehand.
In my experience, employers, because it's such a confusing kind of issue for them, frequently end up producing payroll, which is not really a similar worker, where they would be better served by sending in a letter saying there is no employee who is similar to the injured employee, either because of seniority, experience, etc. Let's see, rule number 35. Concurrent employment. Workers' Compensation Law, Section 14(6). If the injured employee is concurrently engaged in more than one employment at the time of injury, the employee's average weekly wage is calculated on the basis of all concurrent employments covered under this chapter. The employer in whose employment the employee was injured shall be liable for the benefits that would have been payable if the employee had no other employment. When the Special Disability Fund was still around, that extra money that had to be paid to the claimant as a result of concurrent employments used to be reimbursed by the Special Disability Fund. It no longer is. So this can end up actually being an incredible burden on an employer. For example, if somebody's primary employment, the job that they work to live, is their concurrent employment, and then they just have very minor part-time work where the injury occurs, that employer could end up paying benefits based on a very large average weekly wage when in fact the claimant was only working very minimal part-time hours at that employer. So in other words, you have somebody who works 9 to 5 as an office as a paralegal, and then they also work part-time bartending. And then they get injured as a bartender. So their paralegal wages are likely going to be their bigger of the two wages, and their bartending wages would be smaller, especially if you weren't including the tips. But their wages, their benefits under comp would be based on both wages.
Rule number 36, concurrent employment finding is not appropriate where the claimant was not working for the concurrent employer at or very close to the date of accident. There's a lot of case law on this, and it's kind of a situational thing. But basically, if there's a large gap in time right around the date of accident, we have an argument that the claimant was not actually concurrently employed. So you got to look closely at the payroll records to see, did the claimant really work in the weeks leading up to the date of accident, or did they work months beforehand and had not worked at any time close to the date of accident?
Rule number 37. It's the claimant's burden to prove concurrent employment. So the claimant is the one who has to bring in the payroll evidence. The claimant is the one who has to produce a witness who can substantiate the days upon which the claimant worked, if that's necessary. Because sometimes, just producing a W-2 doesn't tell you when the claimant worked for the concurrent employer. So as Brendan just noted, if it wasn't on the same date, then it's not considered concurrent employment. So the claimant may have to produce an affidavit or an affirmation or actual time cards to demonstrate that the claimant was concurrently employed on the date of accident.
Rule number 38, and I touched on this as a parenthetical when discussing how to calculate an AWW. The number of days a person worked may influence the multiple used to calculate AWW. Typically, a 200 multiple is used for a 4-day worker or seasonal workers. 260 multiple is used for a 5-day worker, and a 300 multiple for a 6-day worker. While not law, on the C-240, there is a provision that working more than 234 days would trigger the 260 multiple. Again, that's not the law, but that is something that judges will frequently apply. And if you're under 234, you have a stronger argument that a 200 multiple should be applied.
Yeah, if the claimant worked 275 or 280 days during the year, even if the C-240 says they were a 5-day per week worker, it is like, I can see that a judge might be convinced that a 300 multiple would be appropriate in that scenario. Moving on to awards. This is a big chunk of our rules today. Rule number 39, causal relationship of burden of proof. It is the claimant's burden, again, like with the concurrent employment proofs, it is the claimant's burden to establish a causal relationship between employment and disability by competent medical evidence. And to this end, a medical opinion on the issue of causation must signify a probability as to the underlying cause of the claimant's injury, which is supported by a rational basis. Mere surmise or general expressions of possibility are not enough to support a finding of causal relationship. We often cite this. This is very often quoted language in board panel decisions regarding the issue of causal relationship.
And transitioning from the mere surmise or general expression language, causal relationship opinions must be founded upon a complete and accurate understanding of the relevant history and the claimant's pertinent medical history, or they will be deemed merely speculative, and that's Third Department precedent in Fox v. Altmar Parish. It's very important. It's something we cite quite often because frequently, through no fault of the doctors, be it an IME doctor or a treating provider, they didn't have access to essential medical records. Maybe it's a diagnostic study, maybe it's something from a prior injury. Without access to that and without having to review that in submitting a causal relationship opinion, it should be fairly obvious that their opinion's speculative because they're not factoring in essential information.
Rule number 41, it is the judge, not the doctor, who ultimately decides the temporary disability. So it's the workers' comp judge who must make all determinations on issues such as disability and degree, classification and or schedule, loss of use. Healthcare providers, whether they be impartial specialists, treating doctors or carrier consultants, submit reports and make recommendations. These are then made part of the evidence to be considered by the judge in making a final determination.
Rule number 42, a claimant's weekly award is subject to a statutory max and a statutory minimum, which is set by the board. For example, the current max is $1,063.05, and the minimum is $150.
Very important that you know the date of accident for a claim because that's the only way to know whether or not what the max and minimum are. Rule number 43, to calculate total disability, you take 2/3 of the average weekly wage, and then you subject it to the maximum, well, not for the minimum because it wouldn't be for total, but well, actually that's true for the minimum for that year as well. So your total disability, if it falls below the statutory minimum, it actually can be less than the minimum, and then you would not multiply it by 2/3. So in other words, if your average weekly wage is less than $150 for an accident where the minimum is $150 for that year, for that date of accident, then your average weekly wage is simply what your average weekly wage is. TT is what your average weekly wage is. You don't multiply it by 2/3.
Rule number 44. Permanent total disability is established where the medical proof shows that a claimant is totally disabled and unable to engage in any gainful employment in the labor market. Where there's sufficient medical evidence of permanent total, the board does not need to develop the record on issues of vocational factors and functional ability. So it's sort of a threshold determination. If permanent total is being raised, it needs to be addressed before an LWEC and LMA trial can proceed.
Rule number 45, the criteria and factors that are used in determining whether the claimant has a permanent total disability, which are really from our permanent impairment guidelines prior to the 2012 reformed or revised permanent guidelines. Those are also used in evaluating whether somebody has a temporary total disability. So the criteria that are in those permanency guidelines are things like the use of an assistive device to ambulate, assistance required to get assistance being required to undress or to get on and off the examination table, assistance being required to perform the activities of daily living, a severe neurological deficit, disturbance of bladder or bowel function, leg or back pain, which causes interference with prolonged standing or sitting, and driving continuously for up to 2 hours. So in other words, TT is the same as PTD.
Rule number 46. Reimbursement requests should be in the file prior to the making of the awards, which are being sought as reimbursed. Reimbursement requests must be filed before the first award is made. It's important to note that these can be made orally at the hearing, but they need to specifically be made before the awards are made, not after.
And in Rule 47, in keeping with additional information about employer reimbursement, that when the employer has made payment of wages in a like manner as work during any period of disability, they're entitled to reimbursement, and they're also entitled to we're on Rule 47. An employer is entitled to full reimbursement for wages paid out of a schedule loss of use award. So in other words, the employer pays wages during the first 2 weeks of disability, and the claimant's maximum rate is $600 a week. But the claimant's actual wages from the employer are $800 a week. So the employer would only be reimbursed at $600 a week unless eventually the claimant's awarded a scheduled loss of use award, in which case the employer would be entitled to full reimbursement for all those payments made, or they would be able to recoup that additional $200 a week that they didn't receive when the award was originally made.
Rule 48, a claimant is eligible to reduce earnings when they return to work at a lower wage rate following a compensable injury, and such lower wage rate is determined to be caused, at least in part, by the claimant's causally related disability. It's an important distinction, but a fairly straightforward rule.
Rule number 49 sort of overlaps with this a little bit, and that's because a lot of my team members contributed to the rules for this presentation. But the distinguishing feature of Rule 49 here is that supposedly no evidence, when a claimant's actually returned to work, no evidence of the ability to earn more or less is supposed to be considered in considering average weekly wage. However, that has been abrogated a bit, in that if the claimant is working very limited part-time hours, you can adduce evidence of the failure to seek work, full-time work within the claimant's restrictions as part of a claim that the claimant doesn't have any causally related reduced earnings.
Rule number 50, it's a milestone. A reduced earnings award is computed by taking 66 2/3 of the difference between the claimant's AWW and their wage earning capacity thereafter in the same employment or otherwise.
And the same is true in Rule 51 for when you're calculating the PPD payments. So in other words, if you need to calculate the rate, not the number of weeks of benefits to which the individual is going to be entitled, but the weekly rate that the individual will be entitled to during the duration of their PPD benefits, you take their average weekly wage, you subtract their wage earning capacity, which is the inverse generally of LWEC, although it doesn't have to be according to board panel decisions, and then you multiply that number by 66 2/3.
Rule number 52, when there's a difference of opinion between the physicians regarding the degree of disability and there's no express agreement between the parties, the board is compelled to direct awards at the lowest conceded rate to avoid any potential overpayment, meaning that if our IME says 25% and the treating doctor says temporary total, awards need to be set at 25% TR, and then there's litigation on that issue.
Rule number 53, when you're determining income for reduced earnings, you should use the gross earnings for the year and not the number in box 1 or 2 of the W-2. The earnings should be apples to apples. And this goes to, like if you use a 260 multiple to calculate the average weekly wage, and then you only use part of the claimant's earnings after they've returned to work in order to calculate their reduced earnings, that's not fair. So you need to use gross earnings and gross earnings.
54, when determining income for a self-employed person, the standard is, quote, mandatory business expenses, which is technically a harsh standard where the business could not currently operate without the expense, and the business had no choice but to pay the expense.
So this is important in determining what somebody's wages from their business income is. Rule number 55, medical reports have to list a specific degree of disability in order to serve as evidence of disability. So simply saying that the person's partially disabled isn't sufficient. It needs to say they're partially disabled of a certain degree.
Yeah, and that instance,
I did not know that.
Yeah, and in that instance, you can get an NME finding where award would be set at $0. NME is always without prejudice, so the claimant can cure the defect. Rule number 56, there is no rule that CCP must be brought to the date of the hearing if there is medical evidence contrary to the CCP rate in the board file, but you must file an RFA2 to request to change the rate as of the date listed on the RFA2.
Got it. Rule number 57. Well, little known fact there, Normie, that every workers' comp check contains an affirmation, or it should, that the claimant's condition has not changed and that they are entitled to the benefits that they are collecting by cashing the check.
And that can be used as supporting evidence in a fraud claim. Rule number 58, if there are no surviving spouses or minor children or other dependents as defined by the law who are entitled to compensation in a death claim, surviving parents or the estate of the deceased worker may be entitled to payment of up to $50,000.
Known as a no dependency death claim. Rule number 59, under Cameron versus Crooked Lake House, which is the seminal decision on loss of wage earning capacity, the board relies upon various factors, including the nature and degree of the work-related physical permanent impairment and or mental impairment, work restrictions, and the claimant's age when calculating loss of wage earning capacity. This is basically the sausage. This was the first case to talk about how loss of wage earning capacity is determined.
Rule number 60.
Did you know this?
Maybe not. Rule number 60, the highest degree of temporary disability that a judge can find is 75%.
So this was true for many, many years. It's a case law. It's by case law, although it has support for this in the statute. And then it kind of fell out of favor for a while. But my experience is that recently this is the rule at the board, that the most you can award somebody on a temporary partial disability is 75%. However, I would encourage somebody to prove me wrong if it's no longer true. We're going to move on to surveillance and fraud as general topics now. 61, under Walbaum's, which is a famous case about disclosure of surveillance, the claimant has to be told of the existence of surveillance prior to testimony. In other words, covert surveillance must be disclosed before a claimant testifies, or you can lose the right to use that surveillance on the issue of fraud, although you could still use it to dispute degree of disability.
And rule number 62, an IME that is precluded under Section 137 might still be able to be used for purposes of fraud.
Which is great, because sometimes that's why you get it. Rule number 63, a claimant's, there's a terrible typo there. Claimants must report work activity while collecting TTD benefits, or they will have been found to have violated Section 114A. So they're like, I didn't know I had to, don't take that. Especially we just looked at the check. The check has the thing that says that they're entitled to the benefits. If they're working, they're not entitled to the benefits unless they disclose their work.
And rule number 64, a conviction under section 114 may lead to forfeiture of all rights to compensation for medical and indemnity, and restitution may be required.
So this is the criminal section 114, not 114A. Section 114.1 provides it's a felony to make a written misrepresentation for the purposes of obtaining compensation, and you can get a disqualification of both medical and indemnity on a conviction of 114, as opposed to what we get under 114A, where you can only get disqualification of indemnity. We're going to move on to schedule losses of use. Rule number 65, to calculate a schedule loss of use without protracted healing period, you multiply the SLU percentage by the number of weeks that the member lost is worth. So for example, if you have an arm, the arm is worth 312 weeks. If it's a 50% schedule loss of use of the arm, you take 312 times 50%, or half of that, which is 156 weeks of payments.
And then 66 is to calculate an SLU with protracted healing. You calculate the SLU under the statute, and then if the claimant has weeks of TTD which exceed the protracted healing for that member loss, which is also provided in the statute, you add those weeks to the total number of weeks for the SLU weeks of compensation. So for example, a claimant with a 50% SLU of the leg had 45 weeks of TTD throughout their claim. Therefore, you take the 144 weeks and add an additional 5 weeks, since PHP for a leg begins after 40 weeks.
67, Rule 67, the doctor should measure range of motion against the contralateral side to determine schedule loss of use, unless the contralateral side also has had an injury. So you're only looking at loss. So if the person could only go up to 160 degrees, couldn't go up to 180 degrees on both sides, then you don't count the loss from 180 to 160 if the contralateral side has the same range of motion.
Rule number 68, SLU versus PPD. Under subject number 461211, the board will proceed to resolve SLU claims for the claimant whose claims have been established for both scheduled and non-schedulable body parts, and who are presently working at full pre-injury wages.
That's that recent one, which says that you can get both schedules and non-schedules. Rule number 69. I just did this for comparison purposes because it occurred to me while I was doing this presentation that it seems to be inequitable. So 100% schedule loss of use of an eye. So in other words, you've lost your eye in an accident, it's been enucleated, and so you're entitled to 100% schedule loss of use, is worth 160 weeks of benefits. And 50% schedule loss of use of the arm is worth 156 weeks of benefits. So those of us who are pretty familiar with schedules, 50%, yeah, that's a pretty high schedule loss of use of the arm, especially these days. But you're not going to be, you can still function and live with, 50% of a schedule loss of use of the arm, whereas 100% loss of use of the eye, it's gone. You can't use it. Doesn't seem quite equitable to me.
All right, turning to medical. When filing a denial for treatment, all defenses should be listed on the C8.1B, or you may waive the defense. For example, do not just state not an established site if there's also an issue of burden of proof or guidelines compliance, because if that site gets established, the judge may find that you waived other defenses. I do believe there's case law stating the one defense that's not waived, if not raised on the C8.1B, is that the burden was not met.
I think you're right about that, Brendan. So rule number 71, CA.1Bs must be filed within 45 days of receipt of the bill. So if you get a bill and you believe that there might be some question raised about when you received it, make sure that you're prepared to provide proof of when you received that bill so that your CA.1B is timely.
Rule number 72, I think, is sort of the same as 70. The CA.1B must list all bases for objection on the form, or the defense is not listed, again, will be deemed waived. It's very important and just provides the attorney who's attending the hearing with more avenues to get the C8.1B resolved in favor of the carrier.
Yeah, I knew that was going to happen. I compiled lists from multiple people, and I was concerned that I might jip everybody out of a rule.
I think that's an important one to repeat, though.
Good point. Rule number 73, the medical treatment guidelines do apply to out-of-state treatment, which was a very welcome change.
And rule number 74, treatment providers have to submit bills for medical care to the employer or the carrier or the TPA within 120 days from the day the medical care was rendered.
I like this particular feature of the statute under Workers' Comp Law, Section 13L7, which is the statute that applies to chiropractors. Basically, the reports of chiropractors or the testimony are deemed competent evidence as to the condition of the injured employee, but competent and not controlling on the issue of causal relationship. We're on rule number 75. I like this because it means that if you have a controverted case and the prima facie or the evidence to proceed to trial is from a chiropractor, if you get an ortho or a neurosurgeon and that doctor provides an opinion that the condition is not causally related, according to this section of the statute, you win because the chiropractor is competent but not controlling. And so it'd be my position, and I've argued this successfully in the past, that the MD is controlling over the opinion of a chiropractor. Moving on to labor market attachment and other. I'm sorry, did you have something about that?
No, I was going to just transition.
Okay, please do. Thank you.
So yeah, turning to labor market attachment, rule number 76, labor market attachment should be raised when the claimant has been found to have a less than total disability, either by the court or by the treating or IME doctor.
Rule number 77, attachment to the labor market can be demonstrated by credible documentary evidence. So in other words, actual documents showing that the claimant is actively seeking work within medical restrictions. Very important that it's within medical restrictions. We're going to refine these rules a little bit as we go forward here.
Rule number 78, attachment to the labor market can be supported with an independent job search that is timely, diligent, and persistent. I assume that it'll be expanded upon more, but for example, if you're searching for work in person, at the very least, you need to submit documentary evidence of the work search in person, listing the job that was sought and the result.
Go ahead, Brendan, and talk about online job searches, because we actually don't have a rule that's specific to that.
Yeah, so same with the online job searches. You need to produce documentary evidence of it. And that can include, so if they, for example, if they have email correspondence pertaining to their job search online, they should be producing that. And without it, you have an argument that they're not complying with American Axle's provisions for staying attached through a job search. And a lot of times those emails can give you more to go off of when litigating labor market, because they might list the restrictions or the requirements, which may not be in line with the claimant's medical restrictions.
Right. It's important to remember that the documentary evidence that has to be produced is supposed to be sufficient for the carrier to be able to research whether or not the person actually applied for the jobs. So to the extent that that documentation is insufficient for us to be able to inquire or to research whether the individual actually applied for those jobs, you can make the argument that it's not sufficient documentation. Rule number 79, attachment to the labor market can be supported by an active participation in a job location service, such as New York State's Department of Labor Employment Services, a one-stop career center, or a job service commonly utilized to secure work within a specific industry.
Okay, and similarly, rule number 80, attachment to the labor market can be supported by active participation in vocational rehab through an adult career and continuing education service, that's Access VR, or other board-approved rehab programs, actively participating in a job training program, or attending an accredited educational institution full-time to pursue employment within the work restrictions. I believe the last time I researched this, that means that they have to be in at least 12 credit hours, but I could be wrong by 1 credit hour.
That's good to know. I mean, that accredited educational institution, I think a lot of people forget that that's required. Rule number 81, involuntary retirement. As a general rule, a withdrawal is not voluntary, or it's involuntary, when there's evidence that the claimant's disability caused or contributed to the retirement. So whether a claimant is voluntarily withdrawn from the labor market is an issue of fact for the board to resolve. An award of compensation is improper is if the sole cause of the claimant's loss of earnings is his or her voluntary withdrawal from the labor market. So in other words, somebody takes a voluntary or an early retirement or a regular retirement, and there's no evidence that the doctor advised the claimant to retire. Certainly they can come in and testify like, well, I was having a lot of trouble doing my job. It was really difficult for me to continue going. And, the judge may take that evidence as something that contributed, showing that there was a contribution to the decision to retire. However, the fact that somebody takes a regular retirement or an early incentive retirement and there's no evidence, medical evidence, reflecting that the individual should retire and they were able to work up, full duty up until the time that they actually take their retirement, all those things militate against a finding of involuntary retirement.
82, light duty employment offers. A good faith light duty employment offer must indicate the position that's being offered, including the requirements and duties of that position, and the position must be consistent with the claimant's medical limitations. In the absence of proof that the light duty offer meets these requirements, the board may not find that the claimant voluntarily withdrew from the labor market.
Yeah, it's really unfortunate. A lot of our employers have good return to work programs and light duty programs, but they don't follow these requirements when they're sending the light duty job offer. I mean, that's a very strong, powerful defense if it's done properly. Rule number 83. When a claimant's disability has not been classified as permanent, there's no presumption or inference of a continuing disability, and a claimant's attending physician has the burden of submitting up-to-date medical evidence that the claimant's disability is continuing. So if there's no evidence in the board file your RFA to get a suspension. Even if the claimant's ultimately going to be going back to the doctor to get an opinion, it's still just smart to bring that case back on the calendar because you never know what's going to happen when you bring it back on.
84, under section 10(4) of the comp law, any person incarcerated upon conviction of a felony shall be deemed ineligible for all benefits provided in comp. All those benefits have ceased by operation section may apply to the board for benefits upon their release from custody pursuant to regulation of the board. Thinking like a lawyer, there's some keywords here: incarcerated, conviction, and felony. All three of those need to be met. They need to actually be incarcerated, convicted, and the crime must have risen to the level of being a felony.
Rule number 85. We got 3 minutes, Brendan. We got to step it up. IME reports have to be served on all providers who have treated the claimant within the last 6 months. So when you're looking at your IME 5, make sure that it lists all the providers who have treated the claimant within 6 months.
86. Schedule an IME 8 to 12 weeks after surgery for a disability opinion.
Not really a rule, but it's a good recommendation. Rule number 87, IME reports have to be served on all parties in a like manner at the same time. So if you're going to be emailing reports to somebody, you have to have an email report for the claimant in order to be able to do it in a like manner. However, it would be permitted. We're going to talk about apportionment now.
Rule number 88, under case law, the effective date of apportionment between two work-related injuries can be as early as the second accident date.
There's so many people who don't understand apportionment, and we do kind of have an apportionment expert on staff in the form of a woman named Shannon Mackey. Rule number 89, under the Cool decision, there is no legal bar to apportionment between a work-related injury and a subsequent non-work-related injury that aggravates the work-related injury and increases the claimant's overall disability. So the person gets an MVA after the comp injury, you can apportion to that subsequent injury.
Yeah, and segueing off that rule, number 90, apportionment between two compensation cases does not have to wait until permanency. That can also apply under rule number 89. I just had that the other day where there was apportionment found for the medical, even though we weren't at the point of permanency, where there was a subsequent non-work-related injury.
And this is, for years and years and years, the board said that you couldn't apportion until permanency, and now they've sort of, backtracked on that. So. Rule number 91.
Yes.
Here's the rule for a non-compensation case, apportionment to a non-compensation condition, which is like a unicorn in workers' comp land, usually has to wait until permanency. It is possible, but it doesn't happen very often anymore.
Yeah. Rule number 92, although the employer who last employed the employee in the employment to the nature of which the disease was due and in which it was contracted is liable in the first instance for benefits for an occupational disease. If the employee contracted the disease in prior employment, the liable employer may be entitled to apportionment.
That's section 44. Basically, if it's a carpal tunnel case and there's evidence of prior symptoms or treatment, you may be able to get apportionment for indemnity against prior employers. Rule number 93. Awards are apportioned off the maximum rate for the date of accident for that claim without reference to the rate on apportioned files. So here's an example, right? So you have two claims, earlier claim, later claim. The first claim, the max rate, for example, is $400. And on the second claim, the max rate is $800. All right, if there's an overall 75% disability, all right, the 75% disability is applied to the maximum rate of $400 on the first claim, and then the apportionment is made. So a 75% on a 400 would be $300, and if it's apportioned 50-50, then it would be $150 would be paid on the first claim. The alternative way to do that would be you would say a 75% rate on the $800 would entitle the person to $600, and then apportioned 50-50, it would be $300 against the first claim. And that would be under the max rate for that claim, but that's not the way the board does it. The board applies it on a claim-by-claim basis.
All right, turning to just some sort of miscellaneous rules. Number 94, MMI means a medical judgment that one, a claimant has recovered from the work injury to the greatest extent that's expected, and two, no further improvement in his or her condition is reasonably expected. The need for palliative or symptomatic treatment does not preclude the finding of MMI.
Nor does the possibility of surgery in the future. Rule number 95, the consent of the carrier or employer to settlement of an action brought under workers' comp law section 29 must be obtained, or the employee loses their rights to benefits under the comp statute.
And rule number 96, the consent of the carrier or the employer to discontinuation of an action brought pursuant to section 29 must be obtained, or the employee loses all rights to benefits.
It's the same thing except for discontinuation. Lots of times, like, the cases just get discontinued and plaintiffs' attorneys don't even think twice about it, but they could discontinue an action because it was a crap action. And if they don't get the consent of the carrier to discontinue that action, the person could lose all their entitlement to comp. Rule number 97. I like this. An employer has the right to attend a hearing related to a claim brought by one of its employees. So if you have an employer who wants to attend a claim, they should be able to do it. And that doesn't matter whether or not they're a self-insured employer or they have a carrier.
98, an employer that has insurance coverage for its claims is not entitled to demand that a claim be controverted, as the carrier has assumed liability for the claim.
I'm going to do this rule super fast because it's a great rule, but it's very long. You can suspend, even if you're under a CCB, you can suspend without a hearing under a variety of scenarios, and you don't need an RFA and you don't need to ask for a hearing. The first scenario, where the claimant's return to work and you have proof of that return to work and they're earning in excess of the average weekly wage. Secondly, where the, maybe I have these reversed, but I'm going off of memory. Secondly, where the claimant's attending physician says that the claimant can return to work without restriction, you can also suspend. So the first two are very similar, so we're just going to lump those into two. The return to work with payroll evidence, where the claimant's attending physician says can return to work without restrictions. And then lastly, where you have proof of the incarceration, the rule section 10.4, where the individual has been incarcerated, you do not have to request a hearing. You can suspend by simply filing your SROI.
Rule number 100, all hearings and proceedings shall be conducted in an orderly manner in order to ascertain the substantial rights of the parties. All parties and participants in any hearing or proceeding shall maintain a civil, respectful, and professional demeanor when appearing before the board or when conducting depositions relative to a claim, and comply with the standards of civility adopted by the board. Parties and participants who are disrespectful or disruptive in any hearing or proceeding so as to interfere with the orderly conduct of the hearing or proceeding will be removed, so the hearing or proceeding may continue in an orderly manner. The
question is, what happens when it's the judge who's not, who's being disruptive?
I have been in a hearing where the claimant was muted in a 32 hearing for being disruptive. So
I love it. Misty Krupka brings up that you can file you can suspend without a hearing and whether the claimant has deceased as well. And actually, you can do it with a third party action too. I mean, it's not in the regulation, but if you've consented to settlement and you've indicated that your consent is effective as of the date of the consent letter, you can also suspend in that situation without an RFA. Lastly, rule number 101. LOMAD is the most aggressive, creative, and collaborative workers' compensation defense firm in New York State, and the Workers' Comp Board is not bound by common law, statutory rules of evidence, or by technical or formal rules of procedure, except as provided by this chapter, but may make such investigation or inquiry or conduct such hearing in a manner as to ascertain the substantial rights of the parties. So this is actually contained in 2 different locations in the statute and the regs, that the board's mission is to obtain the substantial rights of the parties. And then there's an exception to the hearsay rule. But I wanted to sneak that in there about LOMAD because I think it's absolutely true. It's a rule. And then I also wanted to give you some additional substantive information. So congratulations. You have now completed Comp 101. You're ready for next semester, Comp 201. You'll have one of us as a TA. I'm sure that we'll bring it back as one of our courses later on in the year. I hope you've enjoyed today's presentation. We apologize for the technical challenges. And I think what Brenda and I will do is we'll clean up our PowerPoint presentation and we'll do a recording of our presentation today so that we have a clean copy on the web if you have anybody who would like to share this, you'd like to share this with. So thanks again for your attention. Sorry that we went a little over, and I hope everybody has a great weekend.